Good afternoon, and thank you for joining us today. My name is Michaela Pochner, and I'm a legal reporter at the Wisconsin Law Journal. This webinar is being recorded, and the recording will be sent out to you via email later this afternoon for your review, or if you'd like to share it with your colleagues. We are taking audience questions during today's live Q&A session, so please send in your questions using the Q&A feature at the bottom of your Zoom window. We'll try to get to as many as we can during the webinar, and we'll follow up with any that we don't answer live. My guest today is attorney Jason Fathallah, a partner at Husch Blackwell's Milwaukee office and a member of the firm's Financial Services and Capital Markets Industry Group. Thanks so much for joining us today.
Thanks for having me, Michaela.
Just going to bring us up here full screen. So I thought we could start right away by talking about, the pandemic is top of mind for everyone. So what does the current landscape look like for business interruption insurance law?
Glad you asked, and it's nice to see that Wisconsin Law Journal is finally recognizing insurance coverage for the exciting area of the law that it is. I'm not sure we've gotten our just due until now. But in a few words, I would describe the business interruption insurance coverage landscape as active, robust, and poised for change. And what I mean by that is there are already at the federal level more than 600 cases pending, and then hundreds more at the state court level. So there's already been a lot of filing activity when you consider that the business interruption has only been going on for a few months. I say that it's active and poised for change because there are efforts to consolidate that are being put forth by the policyholders. And by consolidate, what I mean is that policyholders are looking for ways to handle these claims, not necessarily on an individual case-by-case basis, but finding ways to maybe handle claims or certain common factual questions related to these claims on a more wholesale or global basis. And you're seeing that done primarily in two ways. The first is through multi-district litigation. I know that not all of our viewers are litigators, so I'll just say briefly that multi-district litigation, or MDL, as you might hear me refer to it, is a federal procedural mechanism for handling multiple claims which share common questions of fact and consolidating those questions and claims into one federal court before one federal judge, who then oversees pretrial, discovery, and other pretrial activities, even though each of the cases technically remains separate, individual, and technically part of the court where it was initially filed. So that's one effort that we're seeing right now. The status of that is that the requests have been made, the issues have been fully briefed, and a week from today, the Joint Panel on Multi-District Litigation, which is a panel of 7 active federal court judges, will hear arguments from both policyholders and insurers as to whether an MDL should be created, what it should look like, and if there is to be an MDL, where it should be and who that judge might be. This hearing is actually going to be available to the public. There's a public dial-in that is posted. If you check the Joint Panel on Multi-District Litigation website, I think you can probably find that information there, or at least in an order. And it's really going to be interesting because you have a lot of really prominent lawyers, guys like David Boies, Mark Lanier, who are going to be arguing either for or against MDL consolidation, and the arguments will move quickly. So your viewers might want to tune into that. The other way in which policyholders are seeking to consolidate is through class actions. So most of the claims that have been filed are individual claims brought by one small business or a series of small businesses with common ownership against their insurers. But you're also seeing a series of proposed class actions, both in Wisconsin and across the country, where policyholders are looking to bundle numerous associated claims into one case against an individual insurer. So that's the other effort that we see ongoing right now. And then, as I mentioned previously, of course, you have many, many pending individual cases. We expect a decision from the Joint Panel on Multi-District Litigation probably within a few weeks or so of the July 30th oral argument. And I think that decision is really going to dictate the future course of these claims.
Okay. And I want to come back to the issue of MDLs in just a moment, but we did get a couple viewer questions. First of which is, do you represent the insurers or the companies making the claims?
I represent insurers, not the companies making the claims.
Okay. And then someone did request the website or link for the multi-district, which I will get to following this webinar. And then before we talk more about the MDLs, what are the major legal issues or policy language that these business interruption claims are hinging on?
Yeah, that's a good question. And I'm glad one of the viewers asked who I represent, because I'm going to try to give you the most balanced take that I can on some of these issues. But it's important that your viewers know that these are complicated, sometimes nuanced issues. There are a lot of arguments that are being advanced by the policyholders, and there are a lot of arguments that are being advanced by the insurers. I won't be able to give them all their due justice right now, but I will highlight a few of the major legal issues that you're seeing recur in a lot of these claims. And the first question is, you see this phrase in many business interruption insurance policies that requires there be physical loss of or damage to property in order for the coverage to be triggered. Now, the insurers have taken the position that what that means is there must be some sort of tangible physical change or alteration to the material dimensions of the property. For instance, a fire or flood, something to that effect, in order to satisfy that clause. Whereas insureds, companies, small companies, are taking the position that the presence alone of COVID is sufficient to satisfy that language. And even if it isn't, loss of use or impairment of function would satisfy that language. So that's one major legal issue. Another major legal issue that you're seeing arises in the civil authority coverage. Now, I'll just say very generally, that's the sort of insurance that applies when a government entity has restricted access to a insured location because of some dangerous condition. Think, for instance, there's been a hurricane and a city has been badly hit, there's flooding, and so a government entity has determined that it's unsafe to allow individuals to go to that location. That might be an instance where it applies. The key legal question or the key dispute here is the insurers are taking the position that it must be a total prohibition in order for this insurance to apply. And really there weren't many, if any, total prohibitions because the individuals were still allowed to attend to, clean or to collect mail or perform other backroom operations at these premises. And many of them, including restaurants, daycares, etc., were allowed to continue operating maybe on a different basis or a limited basis. But that will be the insurer position, that because some access was allowed, that's insufficient to trigger coverage, whereas the insureds will take the position that if that total prohibition is not required. The third major issue that you'll see involves the virus or bacteria exclusion, which many insurers have included on their policies, which the insurers will take the position that, as it sounds, it precludes coverage for virus-related claims, whereas the policyholders are taking the position that some of these exclusions are ambiguous. And I've begun seeing some arguments related to representations that might have been made to regulators at the time some of these exclusions were approved, and whether that should impact the enforceability of these exclusions. Now, again, many legal issues that are arising, nuanced from the insurer perspective, fact-specific issues, but those are three of the main ones that we're seeing repeat.
Of those three issues, have the courts issued any rulings related to them at this point?
I'm only aware of one case. It's out of a state circuit court in Michigan, Ingham County, in which the court issued a dispositive ruling finding in favor of the insurers, finding that in that particular case, the physical damage or loss component wasn't satisfied, and that even if it was, the virus exclusion would preclude coverage. I'm aware of some other procedural rulings that perhaps touch on some of these issues, but I'm not aware of any other substantive rulings. I will say that a lot of these issues have been teed up in the form of motions to dismiss that have been fully briefed, but we haven't gotten many decisions, at least that I'm aware of.
Okay. And if an MDL is created, where do you see these cases going?
That's a really good question, and that's going to be the subject of much debate and argument at the July 30th MDL hearing. So I think the first thing to note is that not every request for an MDL is the same. We have some insurers who have requested MDLs against individual insurers. We have some insureds who have requested MDLs that are based on a particular region, because not every insurance company has issued policies throughout the country. Some are state or region based. And then you have some who want to see all the cases transferred to an MDL, but disagree on which court should ultimately be selected. Now, what the Joint Panel on Multi-District Litigation will be asked to do is not only decide whether the cases are appropriate for consolidation in an MDL, but if so, which court and which judge should hear that. And so we'll be hearing some arguments about that. Now, if an MDL gets created, the next steps will be to transfer the existing cases into the MDL, those that fit the defined criteria of the types of cases that qualify for MDL treatment. And then I think you'll probably see a fairly substantial avalanche of additional filings of what we call tag-along actions, which then also get swept into the MDL. At that point, those cases are, the court will try to find a way to handle pretrial discovery and other pretrial issues, including even potentially tackling settlement on a global, more wholesale basis rather than case-by-case basis. And if that does happen, I think you can count on there being a lot of disputes between the policyholders and the insurers as to how those issues should proceed.
Are most policyholders in favor of the MDL, and then most insurers thinking, no, we don't want this?
That's a great question. I can say that from the insurer perspective, I've seen, I think I've seen uniformity in opposing an MDL. Certainly if an MDL is created, I think insurers will have differing opinions of what that MDL should look like and where it should be. Now, in terms of the policyholder side, I certainly can't speak on behalf of all policyholders, but in terms of those who have filed briefs addressing the MDL proposal, those that have filed briefs with the Joint Panel on Multi-District Litigation have taken some differing positions. I think the majority would like to see an MDL, a single MDL created for all cases. But as I mentioned previously, you have some policyholders who are going to argue that there should not be any MDL. I think those policyholders might argue that it would lead to slower results and maybe they have less control over their own individual case. You're going to see some policyholders argue for insurer-specific MDLs against those insurers who issued maybe more of these sorts of policies and have more of these sorts of claims pending. And then, as I mentioned previously, you'll have some that are advocating for a regionally based MDL.
Okay. And if an MDL is not created, then what happens with these cases?
Then the cases just stay where they currently are. They are all currently venued in a federal district court. At that point, they then get litigated as cases ordinarily would. And that'll mean for a lot of these proposed class actions that there will be some class certification issues that have to be addressed. But at that point, really the only way to get these cases consolidated would be, well, the likeliest way I should say, would be through class actions.
Okay, makes sense. And then in terms of the pandemic's effect on the language of insurance policies, what does that look like? And are insurance companies already changing policy language as a result of the COVID-19 pandemic?
You know, I don't know whether there are any internal discussions ongoing about modifying language, but I can tell you that my take is that it would be premature to do that. I will say that there were some insurers that maybe didn't always issue the virus or bacteria exclusion. I think it's fair to say that those insurers are now issuing those exclusions. I think it's also fair to say that as we begin getting decisions from courts and maybe start seeing some uniformity potentially among the courts, or at least a majority of courts deciding certain ways, then I think it's very likely that you'll start to see some of the insurance policy language adjust to meet that changes, those changes in the law potentially.
Okay. And then we did get another viewer question that I'd like to ask. Our viewer asked, what is the landscape with regards to non-compliance with contract provisions due to force majeure?
So that's a slightly different issue. In a lot of commercial and business contracts, you'll have a provision that's called a force majeure provision, which essentially says that if there is some sort of an event that makes performance of the contract impossible, the parties are going to handle it a certain way. Those issues aren't occurring in the business interruption insurance coverage cases that we're looking at. Certainly there are some parallels over what constitutes how you label some of these events. But other than that, the force majeure isn't playing an active role in the business interruption insurance coverage cases. But there is a very large body of law that's developing right now. And I am aware that some courts, I believe, have issued some rulings relative to that. So I'm sure there is some lawyer out there who's watching right now who can answer this question much more thoroughly and accurately than I can.
Okay. Thank you for the information, though. And then kind of switching gears here, talking about another impact of the pandemic or how the pandemic has impacted you personally. You've recently made a major change in the midst of this pandemic. You joined Husch Blackwell as a partner after working at Von Briesen as a co-chair. So when lawyers are thinking about, when they're evaluating making a lateral move, what should they think about, and how does that differ from the factors that people are considering when they're going from partner to associate?
Well, I think the first thing I'll say is do your research on global pandemics and do your best to plan around them, because they can certainly present a few challenges. But more seriousness, the what an attorney should be doing, I think, depends on that individual attorney's present circumstances and what they're looking for out of their career. But I would say the how is fairly uniform, and that is that it requires a lot of diligence. It requires a lot of time, a lot of effort, a lot of research, because it's a very significant decision. It's a very significant decision for the individual attorney. It can be a very significant decision for their family. And then without question, it's a very significant decision for their clients and for their existing book of business. Now, in terms of my personal situation, and perhaps this is what would distinguish partners and associates in the job search front, is that I was very concerned about finding a location where I can bring my existing practice and could serve it the way it needs to be served, and continue to grow it in the ways and in the directions that I would like to grow it. So that requires making sure, number one, that the sort of law that you practice, the sort of business that you do, fits with the business that your firm does. That's commonly referred to as business conflicts. I represent insurance companies. It would be difficult for me to join a firm that has an active policyholder bad faith practice, for instance. And then, of course, you need to make sure that the ethical conflicts are cleared. Even if you can get 99% of your cases cleared, the 1% of cases that you can't get cleared might be the bet the company litigation that your client is facing, so the move might not make sense under those circumstances. And then, of course, you want to make sure that it can be a turnkey transition. The cases don't slow down, the cases don't stop being filed, the claims don't stop coming in, so you need to make sure that you can keep up. And that means a lot of additional time, but it also means making sure that the firm that you're moving to already has the infrastructure and the resources in place to be able to accommodate that practice. And I was fortunate enough that I was given all the information about what Husch Blackwell could do to accommodate my practice. And then since that time, they've fulfilled every promise. Frankly, it's been top notch.
That's great to hear. Are there any specific challenges or surprises that you encountered during your transition?
Yeah, so the non-COVID related, I would say just how time consuming it was. And I think that's out of necessity, because in order to really do your due diligence and to make sure you're making the right decision, it takes a lot of time. I do wonder if that's the reason why we don't see more partners move laterally than we do, because it is such a tremendous inconvenience. So I would say that that's been a surprise. In terms of a challenge, I would say the challenge is presented by COVID. It's tough to transition out of a partnership at one firm and then begin a partnership at another, doing it all from home, in terms of learning the technology, getting trained, onboarding with your new clients, meeting your new assistant, your new colleagues, your new teams. But again, it was something that I knew going in, and it was an area where I pushed Husch Blackwell really hard to make sure that they could fulfill all of my expectations and needs, and they've done that. And I think it's important for any lateral attorney who's making a decision, certainly under these circumstances, to understand the challenges presented by COVID and to make sure that their firm can rise up and meet those challenges.
Are there specific things that you asked for that you think other attorneys who are considering similar moves should ask for in terms of resources or support or anything like that when they're thinking about the impact on their clients or the time intensiveness of making this kind of change?
Yeah, absolutely. And some of it is going to depend on how big is the practice that that attorney is bringing over. But I think one major area has to do with conflicts. The conflict clearing process can be extremely time consuming, and that's particularly true when you're joining a larger firm. So I went from a firm with about 175, 180 lawyers to a firm with about 700 lawyers that is in many states. So I didn't have a good pulse on what their practice was outside of Milwaukee. And so I really had to count on the team of experts and the conflicts personnel who can identify all of the potential conflicts. Because remember, sometimes it could be complicated in Denver. You could have one insurance company that's named, but it has parent or affiliated entities who would also qualify for a conflicts check, even though their name doesn't appear on a pleading. So making sure that you have trained professionals in place who can do the ethics conflicts checks. At Husch Blackwell, they have trained attorneys do it, which gave me a lot of comfort. And that also freed me up to focus on my practice, because as I said before, if I were to have spent the amount of time that it requires to clear conflicts, to make sure that files get transferred over, to identify the individuals who can work on a team, to set me up with the support staff and learn the technology on my own, if I were to have to do all those things without the appropriate level of support in place, I never would have been able to focus on my existing work. Now, when I came over, the week I came over, I had an active arbitration that I had to litigate. Meanwhile, we had the business interruption claims that had begun to be filed and had begun to really increase in volume. And I had all my other cases. There's truly no way that I could have met all of the obligations and responsibilities of my cases while simultaneously handling all the backroom transitional work that needs to be done when a lateral move of this sort is being made. So yes, my advice would be to do your diligence. It's tough when you're going through the process, because you're talking to firms that you might be working with and that you want to like you and that you want to like. And sometimes you feel like the tough questions that you're asking might not be received well. But the truth is, if a firm isn't ready to receive those questions and answer them, then it probably isn't a good fit. And it's probably a good thing that you pressure tested it early on and figured out that it wasn't a good fit. So I wasn't bashful about it. I did pressure test all of this because it was so important to me that I could transition everything so seamlessly. And so far it's worked out fantastically. And I would just encourage everyone else to put in the same level of diligence and research.
That's great advice. And was there anything else you wanted to talk about related to either your move to Husch Blackwell or business interruption insurance law?
I would say not in particular, but I would make myself available as a resource on either one of those issues. It can be very challenging when you're a partner or an associate who's considering making a lateral move, because there aren't a lot of people who you can talk to about this sort of thing. You can't talk to your existing coworkers about it for obvious reasons. And sometimes you worry about confidentiality. So If there is someone out there who's going through a similar experience who wants to hear a little bit more about what I've gone through, then please don't hesitate to reach out to me. I'd be happy to talk to you. And then the other thing I'll say on the business interruption is that I hope I gave a fairly balanced and down the middle take. But if anyone wants to talk about any of these issues any further, please don't hesitate to reach out to me.
And the Law Journal will share Attorney Fathallah's contact information with our email. So feel free to reach out, like he said. And thank you so much for joining us today and for all your insight on both topics.
It was my pleasure, Michaela. Thank you very much for having me.
Yes, we're glad to. I just want to make a quick announcement about the future Law Journal webinar session we have coming up for next Thursday. I'm just going to do a quick screen share here. Next Thursday, we'll have Chief U.S. District Judge Pamela Pepper of the Eastern District of Wisconsin and Chief Judge Mary Trajano of the First Judicial District to talk to us about resuming jury trials and in-person court proceedings amid the COVID-19 pandemic. And then if anyone watching has any suggestions for webinar speakers and topics, feel free to contact me. My email is here on your screen. And if you'd like to get involved at a sponsorship level, please contact Jenny Byington. Her email is here as well. Thank you again for everyone for joining us, and have a great rest of your week.